Broadcast is now starting. All attendees are in listen-only mode.
Welcome to Electronic Evidence Essentials, the 16th in our series of webinars for the Bureau of Justice Assistance Capital Litigation Initiative, Crime Scene to Courtroom Forensics Training. This webinar is produced by the National Clearinghouse for Science, Technology, and the Law and the Office of Professional Education at Stetson University College of Law. I'm your host, Eileen Finan, Director of Technology and Distance Education for the National Clearinghouse for Science, Technology, and the Law. Joining me today is our expert, Professor Jules Epstein, a professor of law and director of advocacy programs at Temple University Beasley School of Law, where he teaches criminal law and evidence courses. He is a former partner and serves as counsel at the highly respected Philadelphia criminal defense and civil rights firm Carries and Radofsky. A 1978 graduate of the University of Pennsylvania School of Law, Professor Epstein began his legal career with the Defender Association of Philadelphia. He served as an adjunct professor at the University of Pennsylvania and as a professor of law and the director of the Tayshoff Advocacy, Technology, and Public Service Institute at the Widener School of Law before joining the faculty at Temple. In recent years, Professor Epstein's work has concentrated on capital case, eyewitness, and forensics issues. He has taught death penalty law nationally to judges and attorneys and continues to handle capital cases at the appellate and post-conviction stages. In the area of eyewitness evidence, he has lectured, authored articles and book chapters, and served as an expert witness. This webinar is designed for both prosecutors and defense attorneys. Attendees who complete this webinar will be eligible for continuing legal education credits. The Stetson Office of Professional Education will work with each individual participant for reporting specifics. CLE applications will be made to Florida and other states per individual requests. Please email ope@law.stetson.edu for further information and state-specific requests. While the webinar is in progress, you can chat with us at any time. Use the chat feature found on the right-hand side of your login screen. We will answer as many of your questions as possible, but please note that we may not get to all of your questions during our streaming event. Although eyewitness evidence is commonplace in legal proceedings, misidentification by eyewitnesses is among the leading causes of wrongful conviction cases. We appreciate the experience and insights Professor Epstein will be sharing with the legal community on this important topic. I now turn things over to Professor Epstein, and we hope that you enjoy the webinar.
All right, so welcome to everybody. One quick correction. Apparently on some of the materials, this was mistitled as Electronic Evidence Essentials. So this is eyewitness evidence. So a couple of people emailed in questions saying, I need some advice on electronic evidence or cell towers, not what we're covering today. But I will note that for everyone who pre-registered and submitted a question, I've made a list of them. Some will be clearly covered in our lecture. Those that are not explicitly covered, I will address at the end. So here we go. This is a lineup from an actual case. And an important lesson is whenever you look at a lineup, if you don't know who the suspect is, but someone stands out like a sore thumb, you might say that's an indicator of an unfair or unduly suggestive lineup. So if we were in a room all together, I would be asking people, does anybody stand out like a sore thumb? Whenever I've done this live, the response is usually the person in the middle. And that's right. His name is John White. Mr. White was accused of rape, which means that the rape victim was sitting 10 or so feet away from the lineup and picked him out. Years later, Mr. White was exonerated by DNA. This is a single source case, and he was not the guy. But here's what's stranger. You see this fellow over here in the striped shirt? By coincidence, the actual rapist, because DNA showed him to be the actual rapist, was in jail at the time of the lineup and was put in the lineup, which means that the rape victim, and presumably there was some time to see the face of the assailant, was looking right at the rapist, but due to problems with memory degradation, incomplete memory, memory contamination, couldn't see his face and somehow saw that of Mr. White, an innocent man. So to me, the John White story is as good a beginning place as any to talk about eyewitnesses are important. They're often right. Certainly we want to corroborate what they say, but there are inherent weaknesses in eyewitness testimony. So what will we cover today? I'm going to give you a little bit of history just because it's kind of interesting. I will do my best. I am not a psychologist. I've never done original research on eyewitnesses and memory, but I've read tens, if not hundreds, of research articles. I've taught with research psychologists, and I have served as an expert witness. So I know the basics. We'll do a little bit of Eyewitness Law 101, and then I want to talk about investigation. Let me make clear what I will not be talking about, although it may come up in one or two questions. I am not going to be talking about, if you're a defense attorney, how to spin any of this to make the eyewitness look less reliable, or if you're a prosecutor, ways to look an eyewitness more reliable. This is meant to be a neutral training. I gave it last week at a public defender's office. I gave it about a month ago at a local prosecutor's office where I spoke to prosecutors and prosecutors' detectives. It's meant to put everybody on the same page and say, what do we all need to know? So there are 4 pictures up here, actually 3 pictures, and a mystery person, Karl Marx, a much younger Jules Epstein, the now deceased Justice Antonin Scalia, and who could it be? So I'm going to show you a quote and then ask, then if we were in a room, if you know who wrote them. Here's the quote. Right? Without persuasive extrinsic evidence, one cannot know for certain which identifications are accurate and which are false, which are the product of reliable memories, and which are distorted by one of a number of factors. That's a remarkable and strong statement that basically means if you had 2 eyewitnesses, one after another, they might sound identical in their certainty, in their descriptive powers, and one might be absolutely right, one might be absolutely wrong, and without some external proof, you would not know for certain which one was which. So it wasn't Karl Marx, it wasn't Justice Scalia, and it wasn't even me. I guess I'd say it wasn't I. This was the New Jersey Supreme Court in an extremely important case called Henderson, actually a case where I was an expert witness, unanimously discussing what the state of knowledge is about eyewitnesses. You can't tell, none of us has a litmus to be able to tell just by listening to the eyewitness. Is that person correct or honest but mistaken? A rather scary notion. One of the questions that was asked is, what is the rate of error? Well, I'm going to jump to the questions now and say, there is no way to tell overall how many people are wrongly convicted by eyewitnesses. But this is an important study. This is actually a byproduct of a study of the two kinds of lineups, or these were photo arrays, what are called simultaneous and sequential. And simultaneous is when all 6 photos are shown at once, and sequential is when they're shown one at a time. And the intended purpose of the study was to see which one produced more accurate responses. But if you look at the lower right-hand side, 41.6% picked fillers. And in the sequential, which some people argue is a more accurate form of process, even there, 31% made wrong picks. Those are pretty stark numbers. So is mistaken identification a real problem? We heard that in the intro. Certainly of the DNA exoneration cases, eyewitness identification is a core issue. If you were to take the greater universe of wrongful conviction exoneration cases, you might say, oh, maybe not, because you could have hundreds of cases that were wrongful convictions based on a laboratory error. But anyone who's gone to law school, and my understanding is that is everybody in the audience, knows this quote: the vagaries, the weaknesses, the variabilities of eyewitness identification are well known. The annals, the history books of criminal law are rife with instances of mistaken identification. The United States Supreme Court, late 1960s, and it goes on from well before that. To me, a really important book or booklet, and this is something, if you've never gotten it, you can simply do a web search and download it as a free PDF, is this report that was commissioned by then Attorney General Janet Reno. And the report's called Convicted by Juries, Exonerated by Science. And after the first 20-something DNA exonerations, and to her credit, Attorney General Reno said, we have to take a look and figure out what's going on here. And she put together a blue ribbon panel of experts of various sorts, and they put together this report. And to me, it was the first government report post-World War II that I'm aware of that really brought home, hi, there is a problem with mistaken identification. Because besides a general overview, a sort of post-mortem summary was done of each of the DNA exoneration cases. It's a fascinating read. But it goes back before that. There was a guy named Borchardt, and my recollection is his first name is Edwin. Borchardt, around 100 years ago, worked at the Library of Congress, and interestingly, back then, did a study of wrongful convictions. He ended up writing a book about it. In his book, he had a total of 65 exonerated people. And obviously, this is pre-DNA. His numbers were that 44 out of the 65 were convicted primarily on eyewitness identification. Important numbers. Also eerily consistent with the numbers that you'll get from a group like the National Innocence Project, where it turns out that their numbers show in the 65 to 75% range of DNA exonerations, mistaken identification. It's a fun book to read. My memory of it is that there's one defendant Borchardt writes about, and the defendant was convicted of passing bad checks and a whole bunch of people, I guess merchants, said, oh, he's the person who did it, so he goes to jail. Guess what happens? More bad checks are passed. They finally capture the real person. They bring this wrongly convicted person down from prison. And the prosecutor said something to the effect of, I never saw two people who looked more dissimilar. I don't think I have a slide on this, but I will tell you that in the late 1800s in England, there was a notorious case. It's called the case of Adolf Beck. Again, numerous people were fleeced, ripped off. Beck was identified. Beck goes to jail. Beck gets out of jail. There's more fraud. They get Beck, and it happens again. And now they realize it's not Beck, and it caused quite an uproar and actually a parliamentary inquiry. So it's not just now, it's not a fad. It's something that's been with us and probably will be for a while. And here are some lessons from the DNA exoneration cases. If you haven't read any of his work, you might want to look up Professor Brandon Garrett, G-A-R-R-E-T-T. Great author, great thinker, great teacher, and he has made it his business to do a deep, deep dive analysis of the DNA exonerations. Here's some data. Here we go, 79% eyewitness mis-ID. Again, not just bystanders, but a lot of these are rape or assault cases. And 7 were people who know the accused and said, oh, that's Jules. And it turned out DNA showed, no, you were wrong. It's not Jules. So the fact that somebody knows me does not mean that that person got it right when that person said, it was me. And we're going to talk about race later, and this was one of the questions that was posed. But again, just doing the numbers, when you look at the victim race, it is largely Caucasian. When you look at the exonerated defendant race, it's substantially African American. So we will talk about later what some people call cross-race bias, what others call own race bias. It's the same thing. It doesn't mean bias as in prejudice. It means a cognitive process where it's easier to identify people like you than people who are less like you. But those are some numbers. Okay, so that's a background, right? We've sort of set the table and said this problem is real. I suspect no one would be listening to this if that person did not think it real. But now we have to go to, okay, what's the science? And so we're going to do a little Science 101. If there is a single lesson to take away from today that you are not already aware of, is that the mind is not a video camera. There is nothing in our mind that catches an image, digitizes it, and stores it perfectly and without alteration. Memory is a process. It doesn't always get accurate or complete information going in. The information that it does get does not remain unaffected while it's in your storage system. And sometimes what's called the recall process, stage 3, when you're asked to bring that memory back up, further distortion or change can occur. So there used to be, and I've read books on the history of memory and different eras and how memory was thought of. It used to be believed that there was like a flashbulb memory, that that picture would be taken and it's burned into your brain. That's not what science knows now. But there are people who are a little bit differently wired. They're called super rememberers. And there are people who are so great at facial identification that, in fact, the police in England find such people and use them to go through their video surveillance, because there's an awful lot of video surveillance there. And I don't have the site, but if you were to go to the New Yorker magazine and do some sort of web search, there was an article about them. So some people are super rememberers. The only problem is we can't tell who they are in a courtroom. They would have to go through some sort of actual testing to see if they have that skill. I will add, and I don't have a slide on this, there are people at the other end of the spectrum. There's actually a condition, I hope I say it right, called prosopagnosia, where people actually see blurred faces and just can't see it, and they compensate by using voice or other things. So yeah, there are some people who are terrific. It's not the great majority of us. And whenever I give this lecture, especially to law enforcement, I say, don't take my word for what I'm about to tell you. In 2006, the FBI published a text called Violent Encounters, and it was more or less a training document for police, law enforcement, who witnessed and or were victims of violent encounters, high stress, high intensity, like crime victims. And there's a section in there on police as eyewitnesses where they discuss a lot of the science I'm going to discuss with you today. And it's accepted. And the fact that you're a police officer doesn't make you a better eyewitness in a violent encounter situation. You're still a human, you still have a brain, you still have the vision and memory issues that we all have. So I talked about stages of memory. The scientists who write about this name them a little bit more formally. And so stage one, at the moment the witness, the victim, the somebody is observing and inputting, that's called the acquisition or encoding stage. Again, once it's up here, it's like all our other memories. What did you eat for lunch yesterday? Where did you go on your last vacation? What was the name of my high school English teacher? It's up here in various stages of accuracy or inaccuracy, and memories can change during storage. And then, as I said, there is retrieval. And what we'll be doing is walking through some of the science that shows factors that can affect memory at each of the three stages. But here's what we're going to do. We're going to test your encoding skills. I'm going to give you 3 exercises. 2 are rather simple. The third is I am going to show you a crime. And unlike at least most criminals, we're not going to say, hello, I'm about to commit a crime. That's not what most criminals do. But when I show you the crime, I'm going to tell you to be alert, because afterwards I will show you a lineup and ask you to identify the person in the lineup who committed the crime. But here's our first thing. I'm going to show you a slide for 2 seconds, and then I'm going to make the screen blank. And if we were in a room, I would ask, what did you see? So maybe you want to grab a pen and paper or just have your mind ready, because I'm now going to hit the slide and say, what do you see? What do you see? Now, if we were in a room, okay, I would ask, what did you see? And I'll bet some of you saw a bunny rabbit. I'll also bet some of you saw a duck. Let's look. So it's either, if you treat the things on the left of the screen as a beak, that's a duck's face. If you treat them as ears, that's a rabbit's face. And you might say to yourselves, great parlor trick, Jules, but what does this have to do with eyewitnesses and their reliability or unreliability? Well, it's our first lesson in psychology that people look at certain details and sometimes fill in or complete a picture and may miss other details. And things change depending on your framework. If I were presenting this at a duck hunters convention, we might get a lot more ducks in the selection. But that's number one. Okay. I am now holding up something that I hope you can all see on the screen. It's a penny. I'll bet everybody here has seen a penny. So now let's go to our test number 2. This is a penny lineup. There's no cheating. You may not take a penny out of your pocket, but I'd like you to think, which one of these is the penny? They all look something like a penny, and they all have Abe Lincoln. And then we've got some variations in which way Lincoln is facing and what words are on that side of the penny and what words are on the other side. And I suspect many of you are scratching your head. So we did this test when we were setting up about a half hour ago, and I had to pull out a penny to be sure, but the correct answer is A. So again, you're saying, great, Jules, but this isn't a crime. I'm not really focused. But there's a second lesson. And so our second lesson is simple. Sometimes we see things holistically and omit details, or don't pay attention to the details. So I've seen a penny, I don't know, 10,000 times in my life, 100,000 times, but I had to go back and check the details. So again, why is that a problem? Because sometimes an eyewitness sees a general face and gets a general picture, but may focus on some details to the exclusion of others. I think our duck-rabbit problem, or miss some details, because we all do. But here's the third one. I am now going to show you a crime. I'm going to give you the context. You're going to be having the view of someone inside a university building, and we'll be going through the building into an office. We're going to look out the window of the office, and out on a sub-roof outside of that office, a man will be planting a bomb. You're going to watch him plant it. He's going to look up and see you watching. And then he's going to run, but we're going to get one more look at him as he runs. So I want you to pay as good attention as you can. And as I said, I'll then show you the lineup and ask you to pick which person in the lineup is the bomber. And for that one, we're going to have a poll showing up on the sidebar, the control panel there, and you'll be able to mark your results. So here goes. Just please watch. We're in that building. There was the roof. You could almost see it. We're going into an office. It's a messy professor's office. We're going to look out that window. And it's out that window that the bomber is. There he is. So please watch. He's going to look towards us. Make sure you get a great look when he turns towards us. There he is. There he is again. And now you're going to see him coming down this hall one more time. Get ready. Here he comes. One more look. And there he is. So get ready for the lineup. So we're going to hold the screen here, and I'm going to ask that the folks who are managing this open up the poll. I will say I'm not seeing it yet. And there we go, poll open. Okay. So it looks like I have to do a click here, so hold on. Okay, I'm not sure what's going on, my friends, but I'm not seeing the poll. So I'm going to ask if, Eileen, you have the poll? Can you send me a chat and let me know? Okay, well, since I'm not getting some feedback, somebody wrote, I see it. So somebody sees it, but I don't. Can somebody get me the results, please? Eileen, I'm sorry, it's not on my screen. I don't know if I need to click something.
I'm not sure either. This is Julie. But I do see that suspect 1 got 46% of the vote. Suspect 2 got 3%. Suspect 3 had 41%. Suspect 4 had 5%, and 5 or 6 answer in chat had 5%. And let me see if we've got any chat responses on that. I don't see any chat responses as to which they picked, 5 or 6, but that's what we have so far.
All right, well, thank you. So I hate to tell everybody this, but the answer is none of the above. So I realize I did not give you that as a choice, and that was actually deliberate on my part. I did not give you that as a choice because that is something we will learn is called a system variable. That if you don't give people the choice of none of the above, they will assume the perpetrator is there. Second to that is you're all pretty bright and caring people and careful people, and you all apparently felt confident with your picks. So you watched a crime and got it wrong. All right, let's move on. So we're going to do a little bit more science, but I'd like to do a little bit of law stuff, okay? So let me do a tiny bit of law, and you'll see in the lower right-hand corner, it says, welcome to Henderson. There are a few really important state Supreme Court decisions on eyewitness identification in the last decade. One is the New Jersey Supreme Court case, State v. Henderson. And we'll talk about that in a bit, but let's look at some basic law. All right. I am confident when I answer this question, no. Notwithstanding the brilliance of my cousin Vinny and his ability to shake all the eyewitnesses, as I indicated earlier, and the New Jersey Supreme Court found, it's hard to tell which eyewitnesses are correct, which aren't, and we really want to get this fixed beforehand. But I want to show you some things about the tools in the legal system and make some comments about them. So one is understand that some of the science I am telling you is not accepted by the general public. Now, I will admit the graph you are seeing here is from a poll that's about 12 years old now, or 13 years. But that's 2005, 2006. So here was a proposition that people were asked, you to agree or disagree with this, that memory works like a video camera. And you can see from the green that a significant portion of the public, more than 60%, agreed or strongly agreed with that proposition. So unless public understanding of human memory has changed radically, you are in a place where the people making judgments will be judging things on a non-scientific basis. There are some ways to address that, but that is a concern for the legal system. All right. Interestingly, again, the testimony of one confident eyewitness should be enough to convict a defendant. Now, we're a little lower there, but we're about 37 or 38% agree or strongly agree. The only problem is later we will talk about confidence is not always correlated with accurate or accuracy. So again, a disconnect between what science shows and what the public knows. So that's concern one. So what about cross-examination? So all of us who went to law school and all of us who practice in courtrooms, and you heard I was a public defender and I was trying murder cases until I think 2003. Cross-examination is the greatest legal engine ever invented for the discovery of truth. I actually wrote a whole article saying not in eyewitness identification cases. And the simple reason why is this. Cross-examination was designed to show lies. It's not the greatest tool for exposing an honest mistake. The eyewitness is not a witness you want to beat up on if you're a defense attorney, and doesn't deserve to be beaten up. This is someone who's a victim or someone who's seen something terrible and is coming forward with no axe to grind. And sounds believable. So cross-examination, I'm going to suggest, not only do I have a problem with the knowledge base of our audience, but the tools we often rely on are exposed lies tools, not exposed mistakes. What else? And this is interesting, okay? There was an experiment done where cross-examination occurred, and sometimes you'd have the A team and sometimes you'd have the D team. The mock juror outcomes, largely the same. So it didn't make a significant difference in terms of the skill level of the cross-examiner. So here's my view on the folly of cross. In one mock jury study, 72% found the subject guilty when there was one eyewitness. When cross-examination showed the witness was legally blind, right, it dropped 4 points to 68%. So we've got some problems here on whether cross-examination alone can overcome this belief of she wouldn't identify the person or he wouldn't identify the person if they didn't really believe it, and if they really believe it, it's probably true. So that's a limitation. Well, wait, we can move to suppress evidence. Well, I'm going to suggest to you suppression rarely occurs. It's got a very high threshold, or maybe said conversely, for the proponent, it has a very low threshold. And the law also is not really designed to incorporate science. So let's take those one at a time. Right? This is pretty interesting. There's an inconsistency. When there is a Fourth Amendment violation, for example, a completely unlawful stop, and then there is a show up, it's automatically suppressed and you require clear and convincing evidence for the in-court ID. When there's a Sixth Amendment violation, you were entitled to a lawyer at the lineup. There was none. You have this same automatic suppress, clear and convincing. When there is suggestivity, the prosecution need simply show reliability, the offset of suggestivity, by a preponderance. Now, I'm not saying that's good or bad, but that's unbelievably inconsistent. And it doesn't make a lot of sense, because a lineup could be beautifully reliable, but we're automatically suppressing it. A show-up could be pretty darn suggestive. And there's not only not automatic, but we're letting it in if there's a hint of reliability. So the law is there. People should litigate these claims. My only comment is, I don't think these are particularly strong tools. Okay? And so again, here are the incompatible standards in my view. Clear and convincing, sufficiently reliable that a juror might be able to find that it's correct. There's a tolerance of untrustworthiness in the adversary trial. So does the reliability standard have teeth? I'm going to show you a case that I suggest proves it doesn't. But first, look at this. Again, this is Professor Garrett. 29 of the wrongful conviction, mistaken ID, we now know they got it wrong, raised suggestive ID due process claims. Not one received relief. So the fact that something happened that led to somebody picking the wrong person, it's not a perfect illustration, but it raises a question. Does the suppression remedy get us anywhere? And so here's Connecticut. When I call it a state to watch, all I mean is actually Connecticut's an interesting state. They've had a lot of state law developments on eyewitness identification, but I want to show you a suppression case from that state. So there's a robbery. And what happened is the perp had been acting like a shopper who spoke with the clerk. The defendant, the suspect's photo is in 2 spreads. And there's no ID in the first spread, which means, in other words, the police came back a second time with new photos, except for that of Angel Luis Sanchez. One could say that that is suggestive, right? And then this was the argument. That ID can't be reliable. First of all, 16 months had passed, and we're going to talk about memory degradation in a little bit. Not only that, look at this. The store clerk's initial description was a young black male, possibly with a tattoo on his arm. But this defendant is 42, no tattoo, and Hispanic. So the defense was arguing, how can this be reliable? Time has gone on, radically different or substantially different descriptions. What did the court hold, which was upheld on appeal? Well, black male is not necessarily inconsistent with Hispanic. And even if there was suggestivity, the ID is reliable. Remember, reliable doesn't mean correct. Reliable means, is it evidence of sufficient quality that a court will say, let a jury hear it? So if some of you have had different outcomes, whether you're a prosecutor or a defense attorney, in terms of suppression, so be it. I'm just showing you cases that show it doesn't take a lot to be reliable and overcome suggestivity. And so Texas, another state, and Texas has also had a lot of interesting and I think very positive developments. It's had a lot of wrongful conviction exonerations. It does training on Eyewitness. It's really a good state in a lot of ways. But I want to talk to you about a Texas identification. Now, this is not the photo spread that was used in Texas, but there was a case in Texas where somebody said the person was wearing a mask, but I could see the eyes. And a court upheld a challenge saying, nothing suggestive here. How can that be reliable? Can anyone really do an identification? So that's a problem there. So in the 21st century, there are 3 cases at least that you need to read. And I should have added to this list, so I'll give you another one later. The Perry case is Perry versus New Hampshire from the US Supreme Court. Perry was a case where Perry's lawyers tried to argue that suppression applies even when there is not state conduct. And they lost. It's an important case. I actually went to the oral argument. It's important because the Supreme Court was asked to rethink the standards for suppression and declined to. It's important, though, because in a footnote, the court acknowledged that the Neal versus Biggers factors, the 5 factors that are generally talked about, are some of the factors to be considered. So for the first time, it seemed to open a crack in the door as to whether other factors might be considered. And that's why you have to read Henderson and Lawson. Henderson is the New Jersey Supreme Court. The story in Henderson is pretty interesting. The New Jersey State Office of the Public Defender brought a challenge in Henderson. And what did they say? Justices of the New Jersey Supreme Court, we think that the 1970s developed suppression standard is bad because it's based on inadequate science. Since then, we've had 2,000 plus articles of research. You folks ought to incorporate science. The New Jersey Supreme Court smartly said, we don't know enough to decide that. We're going to remand. They appointed a special master. The master held hearings. The master had expert witnesses, eyewitness researchers. I testified on a very minor or tangential issue. The master then wrote a lengthy report and went back up to the Supreme Court of New Jersey. When the court issued its Henderson decision, it said, judges, use the science. What we will learn are called system variables and estimator variables in assessing subjectivity and reliability. So if you're in a state where your state constitution or your state Supreme Court's supervisory powers arguably gives the right to give additional prongs to the suppression test, Henderson is something one has to read. What about Lawson? Lawson was the Oregon Supreme Court. And again, I think it's 2014 or thereabouts. And in Lawson, that court said, you don't have to rely on the Constitution. You may rely on things like the rules of evidence, 602, 701, 403, to limit or exclude eyewitness testimony. So those are some really important developments. A little bit more basic law, and then we're going to get back to the science. Obviously, case law is clear as best I can tell nationally. A single eyewitness, the jury has the absolute right to believe. Even if the eyewitness has given some contradictory statements or earlier ID'd someone else. There's just one case saying that, and that seems to be the law nationally. Obviously, the flip side is possible. Texas was an early case saying this, where the eyewitness couldn't make the ID. DNA did beyond a reasonable doubt. So that's an easy one, a little bit off topic, but it's the converse of what we just saw. And this is the case, Roberson, that said that. Okay. You can convict on contradictory eyewitness testimony. You can convict even when the eyewitness testimony describes somebody different. If DNA says, that we'll let the DNA rule. A term to become familiar with. Not all states have developed law on this. Some courts have said that there is something called a confirmatory identification. That would be when I say the crime was committed by one of my colleagues here at the law school and I give a name. It's obvious I know who I'm talking about. So when the police come to me with a picture of that colleague, that's not deemed a suggestive identification procedure because they're saying, well, you told us it was Professor so-and-so. That's deemed a confirmatory ID, right? And sometimes you just can't do it by name, but you say, it's the person who works the 9 to 5 shift at the local grocery store. Things like that will not be deemed suggestive. All right, so we did a law detour. Let's go back to science. So we already got the idea. If memory is not a video camera, what will affect it? So here's the first one, stress. And I'm going to acknowledge now that one of the folks who registered for this posted a question about stress. For each of these, I'm going to tell a little story. In other words, I'm going to tell about the research. So how do we know that stress impairs accuracy of eyewitness testimony? One of the most important studies was done with the US military, what are called SEER, and that's Survive, Evade, Resist, and Escape training. That's the training for people like Green Berets or Delta Force or Navy SEALs to train them what might happen if they get caught behind enemy lines. So they did a test. What happens is these folks are treated as if they're actually captured and they undergo interrogation. Some were interrogated at moderate levels of stress, some at high levels of stress. And then a day or so later, they were shown all the interrogators and said, pick who interrogated you. The group at a higher level of stress had a much lower success rate of getting the right interrogator. The author of that is a guy named Morgan, who's a psychiatrist and a professor at Yale. And so there's a lot written about that. So the higher the stress, it doesn't mean that a particular eyewitness is right or wrong, but that there is an increased risk that eyewitnesses will be wrong. Weapons focus, okay. Our eyes are funny things and our brains are funny things. And when somebody holds up that shiny object, or in this case, that scary object, our eyes may tend to migrate there, even though we don't realize it. How is that tested? Obviously, you don't want to point real guns at people and scare the you-know-what out of them. But in laboratory tests, they do a simulation, and it's done with retinal imaging. And the retinal imaging tracks where the eye moves, and it moves to the gun. So not only is a weapon a potential cause of high stress, but it also can act as a magnet, drawing the eyes away from the gun, from the face, forgive me. This is just a fun one, but something you ought to understand. If the perp was wearing a hat, it makes it harder to distinguish that person from others. Here are four guys, you know, they're somewhat similar, but kind of distinctive, each in his own way. Here are those four guys in hats. And as soon as you put on the hats, and I'll show you the slides together, you lose a lot of discriminating information. So be aware that if hat is in the description or hood is partly up, okay, you may have a risk of an increased risk of mistaken identification just because people will get fewer salient or distinguishing details. So that's hats. Okay, so what am I doing talking about cell phones? Another issue is, what was the eyewitness doing just before the conditions arose where somebody's attention is needed? Okay, so I want to tell you about a study. A person was hired to dress up in a clown suit and ride a unicycle in the middle of a town square. And as people walked from one side of the square to the other, when they got to the other side, they were asked, "Did you notice anything unusual?" Here are the results. So pedestrians, you're listening to music, you're a little bit tuned out, or you're just walking alone, you're sort of in your head, 1 in 3. Interestingly, if you're walking with a friend, and I guess there's more engagement, 60%. If you're talking on a cell phone, only 8%. So let me take you back to stress. The stress thing is a bell curve. Really low stress, not very good. Really high stress, a problem. Moderate stress may be better. That's that bell curve. So it's important to know what the witness was doing at the time of this event to get a handle on how much detail was the person actually apprehending. So now let's talk about race, okay? Does race count? So there have been a lot of studies, and then there are things called meta-analyses where you take a bunch of the studies and you evaluate them, and you take only the best studies and you crunch the numbers. So sometimes we talk about own race or same race or other race conditions. If you take everything as being equal, everyone got the same view, watched the same event. When I am a different race of the perpetrator, the risk of mistaken identification is 1.5 times higher than if I am of the same race. Those are pretty important numbers. And it gets worse. If the viewing time is really constricted, or the time between the initial encounter and the identification is elongated, the race effect grows greater. So those are some daunting numbers. Now, I've used the word race. We should really just say in-group, out-group. These studies have been done around the world. When I testified in a homicide trial recently as an expert witness, I told the jury a study was done in Ukraine about whether Ukrainians were better at identifying fellow Ukrainians than people from India or Africa or China. And the answer was better at identifying Ukrainians. It's not bias, it's exposure, it's familiarity, there are features common to people of your type that you use to tell them apart. That's the phenomenon of own race, or some people call it cross-race bias. Now, some people say, well, wait a minute. That can't be true now. So, and indeed, those studies are done over a period of years or decades. We've had an African-American president. On the other hand, we know there's still a lot of racism in the United States. So what can we really say? It's not that we are in something of a post-racial society, assuming we are, but it's really about the depth or richness or quality of the contact a witness has with people of other races. The more quality contact people have with the others, the more the impact of this is reduced. So yes, we're getting better. It just doesn't mean that magically this has somehow disappeared. And I suspect each of you knows some areas of your jurisdictions where people live in beautiful integrated harmony, and other places in your jurisdiction where there are unwritten neighborhood lines or just limited opportunities to interact. So yeah, it's getting better. My kids are better than I, and I bet their kids will be better still, but it's a phenomenon. Let's talk about time. Another phenomenon is that when you ask a victim or eyewitness, well, how long did the robbery take? You will get an estimate, and sadly, estimates are usually 2 to 3 times longer than what actually occurred. How is this study done? It's pretty simple. You take an earthquake, right? With a seismograph, you can know exactly how long the earth shook. How long did the earth shake? And you get estimates 2 to 3 times the amount. Well, there's nothing to distinguish that from these cases. So, and we'll talk later when we talk about investigation, what I think is a relatively easy way to compensate for this, but be aware of it. Okay, then there's more stuff with time. So I'm going to introduce you to a new term, target present and target absent, 2 terms. Target present means the lineup actually has the person in it. Target absent is the lineup I showed you earlier, where I led you to believe the person was in it, but the person was not. So these are test conditions. Take a look at the false alarm. In other words, you picked the wrong person when you only got a 12-second look versus a 45-second look. The differences are stark. 42%, 45% of older folks got it wrong, whereas almost none got it wrong at 45 seconds in a target present lineup. We still have errors in target absent. People tend to choose. But time counts. There's another thing about time, and it's not limited to eyewitness, okay? Eyewitness and everybody's memory fades over time. This is called the Ebbinghaus curve, named after a researcher named Ebbinghaus. And it can be about eyewitnesses. It can be about what you learn at a law school lecture. You can see that by day 1, that's the thing at the bottom. People have lost about 70% of details. And this is really important. Why? Because the longer the time between the event and the initial report, or the event and the ID procedure, or the event and testimony, details will be lost. So now I'm going to challenge that contention. I suspect everyone here can say, and say accurately, I will never forget September 11th, 2001. We all remember it. So am I wrong? No, we all remember the event. But do you remember this? Which tower was hit first? What airline was it? How many people were on the plane that went down in Pennsylvania? Every one of us knew those details for the first day or two or three. But there are a lot of details now we don't remember or we think we do and get wrong. And there have actually been studies on precisely the issue of memory of 2001, right? And people get it wrong. So yes, the rape victim will never forget being raped. The person who witnessed a horrible murder will never forget that phenomenon. But that's the gist, the event. It doesn't apply to detail. Now I want to get to when we're trying to reconstruct memory. When we ask questions, this is a great bit of research by Elizabeth Loftus, one of this nation's longest term and most accomplished memory researchers. She showed people a video of a car accident. Everyone saw the same video and they were broken into 3 groups. They all got the question in lavender, but each got a different verb. Look at the estimated miles per hour. The verb suggested additional or lower speed. Police questioning, anybody's questioning, can do the same. And it gets worse. In the video, there was no cracked, broken glass. In other words, the car window remained intact. But she brought people back, I think 1 week later, and said, okay, does anyone remember any broken glass? Well, look at the light blue. Those are the people who were asked about the smash. They were much higher than anybody else. So words not only can alter memory, they can contribute to memory. So those are things people have to be aware of and be careful of. And this is just avoid this. Repeat showings. If a suspect's photo is shown once, never show it again. There's a phenomenon called transference, where at this point, if I'm the crime victim and I am shown this photo once, and then in a later photo array, I see it again, my mind may play the trick on me and not tell me, oh, Jules, that's from that earlier photo array. It could be, that's from the crime. It gets transferred over. One show or done, do other investigations. Otherwise, you are at risk of a mistaken identification. Well, what about technology? So I want us to be clear. I think videos are really important and always have to be checked. But they can result in wrong identifications too. This young man on your left in the white t-shirt is Tamir Craig. There was a murder. The local surveillance camera caught the guy on the right, the murder suspect walking away moments afterwards, and somebody said, oh, that's Tamir. And Tamir got arrested. It took several months, and credit goes to the local district attorney's office. This was Delaware County, Pennsylvania, who said, we'll look into this. They sent it to the FBI lab. They were able to determine the height of the guy in the video, 5'11". Tamir is 5'5". So video is good, but it's not perfect. Please understand its limits. I call this recent research. It means in the last 6 or 7 years. These are all sketches, each one done by a woman who was a rape victim DNA ultimately showed that all 9 women were raped by the same man. So we have some similarities, a fair number of differences, but the differences become more pronounced when we go to the next slide. Look at the height, 5'2" to 6 feet, 130 to 200 pounds, 27 to 40. Those are the vagaries of eyewitness identification. This was a very interesting study, actually commissioned by the United States Air Force, where they wanted to see if a pilot got shot down, here we go again, behind enemy lines, could a pilot accurately describe the captor? So the United States could go after that person one day. And they showed people, individuals holding one of 4 things: a saw, a drill, a caulking gun, and a real gun. Well, what were the results? Participants judged pistol packers to be taller than men holding caulking guns, okay? So all sorts of things are going on with our minds in terms of, are they really letting us get an accurate picture of what we were seeing right in front of us? So maybe the most important name in eyewitness research in the United States is Professor Gary Wells, W-E-L-L-S. And if you ever want to see his research, simply type into any search engine, Gary Wells Eyewitness, or Gary Wells, Iowa, because that's where he teaches. And Professor Wells, decades ago, said, look, what are we really talking about here? We are talking about variables, and he classed them in 2 categories. Estimator variables are variables about the crime or the criminal that we can only guess, estimate the impact on. But there are also things called system variables. The description process, interviewing, instructions before the lineup. Remember the lineup, and I told you, please pick the person in the lineup who did it. Bad instruction. Good instruction. The person who did this may or may not be here. If you make an identification, fine. If you do not, we will continue to investigate. Do your best. How you pick lineup fillers. Should they match the original description, or should they match the suspect, or some of each? Do you use a sequential or simultaneous lineup? Do you do post-lineup debriefing? How do you do it? And is the lineup administered double-blind? Double-blind means not only that the witness does not know which person in the lineup is the suspect, but it also means the person running the lineup doesn't know, because when the person does, unintentionally, but there have been studies showing this, there are sometimes cues that were given that distort the choice. And I need to talk about the word confidence. So the confidence lessons or debates are these. Number 1, I think there's strong agreement among researchers that whenever there is an ID procedure, at the end of the procedure, police or whoever's running that lineup or array should take a confidence statement. In your own words, how confident are you that this is the right person? Or on a scale of 1 to 10, I'm not expert enough on which is preferred. But the idea is get it now. If the person's low confidence, you better keep looking into this crime. If the person's middle confidence, you need to know that, because things will happen, and by time of trial, you get exaggerated or magnified confidence. So that's issue number 1 with confidence. Number 2 is, if confidence is probative, It's the confidence at that initial identification that is much more likely to have some probative value than a time of trial. It's rare that you have a witness at trial who's less than, I'm 100% sure. But we know from DNA and other cases, 100% sure months or years later is not the same as I was sure 20 minutes later when they brought me 3 guys and I said, no, no, yes. So I'm not saying courts don't allow witnesses to say, I'm sure. We'll talk about that law issue a little. But I am saying that in terms of science, a time of trial ID confidence statement of, yes, I'm sure, is not a metric for, yes, I'm accurate. Here's the ongoing debate if you want to know what's the latest that's being discussed in eyewitness research. There is a small group of researchers. They've got some pretty good credentials. I think you could say one of the principal ones within that group is a guy named John Wickstead, W-I-X-T-E-D, who take the position that if a witness says, I'm confident, that's him or that's her, or that's them, I'm sure, that trumps all of the estimator and system variables. I'm probably understating or not fully stating their theory, but the gist of it is most people don't say that unless they've already filtered out a lot of these issues. There are other scientists, and there are a larger group of them who say that's not accurate. That confidence rarely correlates with accuracy. And you really have to look at the conditions. Gary Wells and John Wickstead had what I'll call a meeting of the minds and wrote a paper that said, look, if the identification procedure itself is pristine, it's a perfectly run lineup, a perfectly designed lineup. There's no hint, there's no coaching. The person is given great instructions beforehand, and the person is highly confident at the end of the pristine process. Then there's some correlation with accuracy. Other than pristine, Professor Wells was not willing to go that far. Professor Wickstead has said, even without pristine, I'm willing to go there. At the end today, I will give you the latest research article which challenges the Wickstead position. Again, you can also look up John Wickstead and find his articles. Just for now, understand there's no clear science that says confidence equals accuracy. And certainly trial confidence is not a measure of accuracy. So we've got a lot of science, we've got some law. What are we going to do with this? So I want to talk about better investigation. I do some post-conviction work now. I do volunteer work with the Pennsylvania Innocence Project. And so I end up investigating eyewitness cases the way they were never investigated the first time by the defense attorney investigator, or the prosecutor or police. So I want to talk about ways to do it better. Step one, no one can prosecute or defend, or maybe even charge, a serious eyewitness identification case without first going to the scene. Walk in the shoes of the victim eyewitness. Why? Well, I want to talk about lighting. A lot of crimes happen at night, and some of us just say, well, there are street lights there. Well, where were they vis-a-vis the people? You all know what backlighting is. You're sitting in a movie theater and all of a sudden the door at the back of the theater opens and you turn around and light comes shining down. What do you see? The silhouette of the person, but you can't see the face because the light is actually behind. So not only do you have to say, well, I looked on Google Maps or Google Earth and I saw there was a street light. You have to make sure it was working that night. And then where were the people positioned? Of course, going to the scene lets you know if there are security cameras, and that might provide compelling evidence of guilt or non-guilt. But we really need to check the lighting. What else? You must not take the witness's word for we were 15 feet apart. You must go measure, because the studies are clear. After 25 feet, face perception begins to drop off. And don't take my word for it, there are studies. Okay, Jeffrey Loftus, another professor, actually developed a computer program that can show the amount of face detail one can see at various different distances. All right, here's yet another illustration of that. But you don't need Dr. Loftus, although I understand he can be consulted. You can do this yourself. I did. This was a wrongful conviction case. If you look at the far right, sort of front of the picture, that's a barber shop. And what happened on the day of the murder, and it was a bright sunny day like it is in this picture, two guys came out of the barber shop. They looked down towards that corner where in the distance you can see the one-way sign. And on the corner on the other side of that little street, they saw one guy bent over another, fire a shot, look towards them and leave. And they identified a man named Donsha Patterson. Mr. Patterson is now an exoneree. But to prove that this case warranted an exoneration, we did what the trial lawyer never did, and as best as I can tell, the police and prosecutor never did. So we went to the scene, and I saw a guy walking down the street, and I said, may I pay you $5 because I want you to be in a picture? And he said, sure. So we took picture after picture, after picture. And I'm going to go back for a second, because I'll bet when you looked at this picture, you didn't even realize that he's walking a dog. This was part of the package that we submitted to a conviction integrity unit to say, I'm sure these people were doing their best, but the naked eye will show you. You can't tell that. And everybody's got to go to the scene at the time of day with the right lighting and do these experiments. How do you measure time? You reenact. Remember I told you about people overestimating time? Take your stopwatch, act out the crime in the light most favorable to the witness or victim, and then hit stop. And you will know how many seconds it took, much more closely than taking a person's word. That's another critical thing people have to do, because estimates of time are simply not reliable. Interviewing styles. So I'm not an expert on this, but there are better interviewing styles. Some police departments have adopted or are thinking about adopting it. You ought to do a little research about what's called the cognitive interview. It's a process where you sort of say to the witness, just tell me first, give me the scene, set the environment. And then, believe it or not, you say, I want you to work backwards through this event. Tell me what it would have looked like from the guy across the street. Tell me what it looked like from where you were. Tell me all details, no matter how inconsequential. And when they showed people events, and some were interviewed in a standard way and some with the cognitive interview, you can see from the numbers at the bottom of the screen, more correct facts. So there's research being done on interviewing style. Maybe that's what's needed. Okay, sorry, we did have, oh, wrong direction, my bad, sorry. Let's talk about the eyewitnesses at trial. Does the witness have actual personal knowledge? This goes back to that Lawson case. Very few people ever think about, read about, remember Rule 602. One could argue, using the photos from the Donsha Patterson case, that witness should not, the witness should be allowed to say, I saw a guy leaning over. I could see his skin complexion, but not the face. There's an argument. Personal knowledge should be a screen. The Lawson case, 403, look at the difference. That's the guy who robbed me, and that's the guy who robbed me, and I'm 100% sure. Lawson and the Henderson case suggest that certain statement doesn't have to be an all or nothing, but that a judge applying Rule 403 can tone things down, and that may be appropriate in a particular case. Again, this is just language from the Lawson opinion, right? You don't exclude the whole ID, but exclude problematic parts. Please remember, if you are presenting the eyewitness, you not only get to say, is that the person, do you see the person here in court today? But did you identify her at the show up? Did you pick him at the lineup? Did you see the person on TV and call the police, say, my goodness, I just saw the person on TV? Those statements are not hearsay in the sense that they are not excluded by the ban on hearsay. They are admitted for the truth of the matter asserted. How about experts? So the great majority of states and federal courts allow experts. I've now testified as an expert twice. Once was policy in the Henderson case. One was as the trial expert. Experts are not allowed to opine whether this case is a mistaken identification. It's really background and probabilistic, although I'm not giving numbers. My job is to teach. Here is how memory works. Here are variables. Here are the studies. You apply them. Please understand two problems. There just are not enough experts to go around. I was tapped to be an expert because it was an Innocence Project case, Pennsylvania Innocence Project. The eyewitness experts, the psychologists, were just too busy. And I'm not saying I make the greatest expert in the sense that I'm not a researcher. I know this information. But at any rate, yes, they're allowed in a particular case. They might be really important, just they're not the panacea. We don't have enough. What about the almost experts? So New Jersey, if I recall correctly, Hawaii, Massachusetts, some federal courts have considered jury instructions that include some of the science. Couple of notions. To me, the way they're written, they're a little too wordy. I'm a plain English jury instruction person. And of course, they come at the end of trial. I will add that the Henderson case said a judge may, in her discretion, give an eyewitness instruction in the middle of trial before the eyewitness testifies, just like we give an instruction before an expert testifies or before 404B other evidence comes in. Not many judges in New Jersey have availed themselves of that. I did a training of New Jersey judges a couple of years ago, and only a couple of people raised their hands as doing it. But it's, again, something to be aware of. So here's what I'd like to do. I'd like to finish this up with resources and then go down the list of questions And then if we have any that I didn't answer, you can start sending them on to the folks, and then they will forward them to me. So what about resources? I want to begin by talking about Abraham Lincoln. Why? Well, first of all, if you've never read it, there's a terrific book. Hold on one second because I have it. So here's the book. It's called Abraham Lincoln and the Almanac Trial. It's called Moonlight. And Abraham Lincoln tried a murder case where the issue was eyewitness identification. But I'm not telling you his name because of that. That was that story. Abraham Lincoln is also the person who signed into the law the legislation that enabled the creation of the National Academy of Sciences. And in 2016, the National Academy of Sciences issued this report. It's called Identifying the Culprit, Assessing Eyewitness Identification. Let me take a minute to tell you why it's a really important and good quality report. When the National Academy gets ready to do a report like this, they pick a group, a widely diverse group of people. Those people do research and hold hearings and hear from police and eyewitness researchers and prosecutors and judges and vision scientists and memory scientists. And they put together a report. Before the report is published, the report is sent to a number of people who we call blind reviewers. What that means is, and I was a blind reviewer for this report, I get the initial draft and go line by line through it and make any notes that I think are of concern. Something is missing, I'm not sure this is explained well, you never considered this, and I mail mine back in. Other blind reviewers mail theirs back in. Those blind reviews are shown to the original committee, minus our names. So they don't, oh, Jules Epstein said that. They must assess each and every concern and then reach a consensus report. For the United States, this is probably the most recent comprehensive report on vision science, memory science, police best practices, some legal issues, and you can get it for free. If you simply do a web search of identifying the culprit, you can register and download it chapter by chapter. It's really important. That's one thing. The Third Circuit is Pennsylvania and a couple of other states. I'm here in Pennsylvania. And a couple of years ago, one of our judges, then the chief judge of the Third Circuit, the Honorable Ted McKee, wrote a concurring opinion in a habeas decision where the issue of eyewitness testimony was in play. And he wrote a Henderson-like opinion, updated a few years. And he was so concerned about the problem of eyewitness identification that he convened a Third Circuit task force on eyewitness identification. Judges, prosecutor, defense, academic, research psychologist. I think that's pretty much it. And we met and we met and we met, and our report is finally done. It's in the proofing stage. It will be coming out, I'm hopeful, in the next 3 weeks or a month. It will be a downloadable. And indeed, the Third Circuit is also setting up a public access eyewitness resource webpage, which will be curated by a couple of folks from the work group and updated, I think, every 6 months or every year. So that will be an online resource for getting a lot of this information. There are tons of books out there. This one is now dated. I wrote one of the chapters in there, which was a law chapter. Maybe the most important book is called Eyewitness, I think it's Eyewitness Testimony, Civil and Criminal by Elizabeth Loftus, James Doyle, and Jennifer Dysart. I think either the 5th or 6th, the newest edition just came out. I consider it the Bible in this realm. It is the most comprehensive and continually updated book on legal issues, trial issues, and eyewitness psychology issues that's imaginable, from 3 of the most knowledgeable people in the country. I already mentioned Convicted by Juries, Exonerated by Science. To me, one of the most important books any of us in the law can ever read is Picking Cotton. It's the story of Jennifer Thompson, now Thompson Canino, a rape victim who wrongly picked Ronald Cotton. DNA exonerated Cotton. The two became incredible friends. And this is written in alternating voices. It's the story of their case. Let me check if I have, no, before I leave that. I'm going to say some names because if you simply web search these names, web search Gary Wells, Iowa as a place to go to. Gary has a really big eyewitness web page. Another name is Roy Malpass, M as in mother, A-L pass, like throw a pass. Malpass is down in Texas, does a lot of this work. There are a whole bunch of wonderful eyewitness researchers at the John Jay College. 2 names are Jen Dysart, D-Y-S-A-R-T, and Margaret Kovera, K-O-V-E-R-A. If you web search National Institute of Justice, Eyewitness, you will get some really important materials. So let me leave this screen up, but go to your questions. Some were covered, so I'm going to skip over them. One was, can you tell us what is the latest study? So the Third Circuit report, when it comes out, will have research up through 2017, 2018. I can't say what is the most recent study because studies are going on all the time, but there are 2 documents I'm going to suggest you look for. One is if you web search APA, the American Psychological Association, APA white paper on eyewitness identification. The American Psychological Association put together a group that put together its draft report in 2018, and you can actually find the draft report online. It's in the final approval process. I'm not sure where it is there. I couldn't get that information before coming live to you today. But the APA white paper is meant to be a consensus report within the eyewitness research community. And I've read the draft, and it's pretty remarkable. There is also a newer eyewitness researcher named Andrew Smith. If you web search Andrew Smith, Eyewitness, Iowa, because he works where Gary Wells works, he has a remarkable set of very recent papers. And one of his most recent papers also addresses that, does confidence mean accurate issue? And he has some data that calls into question the data and the analysis of the folks who said it does. So you'll get the back and forth there. All right, next question. Do I need an expert to introduce the science? Maybe. You can ask a judge to judicially notice it. I'm not saying the judge will, but you can try. You can propose a jury instruction, which is really a form of judicial notice. Otherwise, you will have to look at the law of your jurisdiction as to whether you may comment on something that you've read in the newspaper or looked up in a science journal in an opening statement or a closing argument. My suspicion is probably not in most cases or most jurisdictions, but that's it. You're opening an innocence project. So congratulations. My first comment is talk to the people who've already done it, which I suspect you're doing. But in terms of eyewitness issues, here are a couple of suggestions. Invite in people like me, or more appropriately, perhaps, people like the Gary Wells and Jennifer Dysarts of the world to train you, your staff, and your volunteers on the science. Invite people in like me to show people how to read police reports, how to read a trial, how to go out and look at the scene and figure out, is this a case where any of those estimator and or system variables might be at issue? Those are your screening tools. A question was asked about trauma, or what I called high stress. And the question, and was from an advocate side, from the defense side, was sometimes prosecutor says that's what makes the eyewitness more reliable. I'll never forget that face. It was such a searing experience, but the science seems to be the contrary. How do I, a defense attorney, respond to that? I really don't want to be adversarial here, but I will try and give an objective answer. If you think that that is ascientific or anti-scientific, you can hire an expert and move to present an expert. You can ask the judge to take judicial notice. You can try and say to a judge, I move in limine to have you rule that the prosecutor can't make that argument. I'm not saying any of those will necessarily carry the day, but just in terms of options, those are ones to do. There's something else. Obviously, if you get a jury instruction, that'll do it. If you get none of those and you don't have the expert, maybe you have to think about a common experience. Everybody's had on Halloween somebody jump out and yell, boo! And they're so startled, they don't realize it's their next door neighbor. It's not the perfect analogy, but it is an analogy that may explain to some jurors how high stress can reduce accuracy. That's just part of the storytelling. And I just saw a note here. I guess you're all seeing it, that all the resources I mentioned will go into a further reading list. So that's great. What do you do with familiarity? In other words, if people are familiar, it doesn't mean they're right. All I can tell you about that is an expert or the DNA cases can show that even if the eyewitness knows the defendant, the person can still be getting it wrong and it might not be the defendant. And that's going to be a matter of the circumstances of the crime and maybe what other system and estimator variables are in play. ID from the video, there are really a couple of issues there. We've already talked about getting that video analyzed. I've seen some cases where defense attorneys or investigating prosecutors could do this also. Hire a forensic anthropologist to do measurements on the face structure and say it does or doesn't match. As to whether a witness can come in and say, well, I live in the neighborhood, on that video, I can tell you that's Jules. That's a lay opinion question, and it's based both on foundation and whether it's helpful. If a jury is equally positioned to draw the conclusion, you don't need it, and a judge might disallow it, but that's applying Rule 701. What do you do if police encouraged a reluctant witness? You interview the witness and you need an expert. Somebody asked about what is the effect of confirmation bias on ID? Is there a quantifiable rate of error in identification due to this issue? I can only say not known to me. What foundation do we need at a Fry hearing? So I've done one Fry hearing. We did one in Pennsylvania because until 2013 or 14, we were not allowed to have experts. And you have to show general acceptance. We show general acceptance a number of ways. Any eyewitness expert will know that there are polls of eyewitness researchers that say, what do we all agree on? They were done by a guy named Saul Casson at John Jay. We brought in a professor who teaches psychology to say this is covered in all the textbooks. We provided a list of other jurisdictions that accept it. We talked about things like the American Psychological Association white paper. We cited to identifying the culprit. We moved a lot of information in. That's how we established general acceptance. Again, question, is there a website? Gary Wells, Andrew Smith, Jen Dysart, Elizabeth Loftus, Roy Malpass, NIJ, places like that. How best do you set the stage for an expert? So again, I really don't want this to be a training on how does the defense do it or how does the prosecution, but let's keep it simple. An expert is only as good as the data you elicit from a fact witness or witnesses. So what you really need to be focusing on is telling the story, learning each system variable, learning each estimator variable, telling the jury in your opening, these are things we're going to learn about this case, and then we're going to bring you an expert who will explain scientifically what they mean. Question, how to combat show-ups at trial? Again, I don't want to get adversary. A show-up is an identification procedure with pluses and minuses. The plus is it is inherently, I'm sorry, that's the minus. It's inherently suggestive. The plus is it's done close in time. Memory is freshest. So I'm going to leave it at that because that's really, you learn the pluses and you learn the minuses and you decide what you're going to do with them. A question was, is the science generally accepted / Daubert reliable? So the answer is, since almost every state and most federal appellate courts have approved use of experts, that's an easy yes. There are plenty of law review articles, I've written at least one, about eyewitness identification that catalogs the states that have done this. You should have no problem finding those data. What can a defense attorney do other than call an expert? And I think I've already talked about that. And I really think this really goes to defense or prosecution. Recreate the crime. Let the jury see what the witness could or could not see. Let them make the judgment that's the right way. Question, does the police interview give me a description or something like that? Potentially alter memory. Well, we saw that from that Elizabeth Loftus slide. There's a difference between tell me everything about the perp's face and tell me about facial hair. The about facial hair could, not necessarily will, but could be a prompt. So you have to find that out. How does an eyewitness, or I'm sorry, how does an attorney screen a case to see whether ID might be a problem? The answer is learn those estimator variables, learn those system variables, reenact the crime, go to the scene, look at everything. Then you're going to know. And that's true whichever side of the courtroom you're on. Can you talk about the accuracy of IDs made from surveillance video? I'm sorry, I personally don't know of any research on that. The last one was a legal question. I think that's our last one, yes. What if there is no lineup, no photo array, no show up, and the first time a witness will be seeing the accused is at trial? Is there a potential suppression remedy? So on this one, and again, I'm very happy that the folks recording this will take my words and type them up. A number of courts have addressed this. I think it's correct that the majority have said we will not do suppression hearings for an in-court only ID. A couple of courts have said, yes, we will. I'm going to give you a citation to a Colorado Supreme Court case from 2019 called Garner, Garner, 436 Pacific 3rd, beginning at page 1116, 1116. That is the dissenting opinion in that case, but the dissenting justice really summarized all the cases going both ways. So you can get your research there. If the court in the jurisdiction you're in does not allow that, you can try a non-suppression remedy, a motion in limine. You can ask the court to stop the trial and say, let's take the witness out of the room before my client is seen. Or if you're the prosecutor, in an abundance of caution, Judge, we can do a photo spread right now and they can watch it. So those are options, but suppression, really hard, except in the couple of states. I believe the main state recently that has talked about this is Connecticut. Okay, so those are the answers to the questions. I have not received a chat text that there are any additional questions. So while I look at my chat box to see, oh, no other questions. So here's the deal. First, thank you all for joining in on this. Thank you, whether you're a defense attorney or a prosecutor, for taking the issue of eyewitness identification really seriously. My thanks to the folks at Stetson and the Department of Justice, BJA, for putting this together. And I hope I gave you something useful. So Eileen, I'm done. What do you have to say?
I say, first of all, thank you so much, Professor Epstein. You did a fabulous job with just chock full of helpful information, and we just couldn't thank you enough. To all the attendees, thank you for joining us today on today's webinar. And please continue to check the Spotlight section of our homepage on ncstl.org for information on upcoming webinars. All webinars are available on demand and can be found on the Education and Training page of our website. And please make sure to fill out the survey that you will be receiving by email. This survey will enable you to receive your CLE information. And contact our Office of Professional Education at ope@law.stetson.edu for further information or questions. And on behalf of Stetson University College of Law, the National Clearinghouse for Science, Technology, and the Law, the Bureau of Justice Assistance, our guest speaker, Professor Epstein, and myself. Thank you for attending.